Does a gentlewoman from Wyoming seek recognition?
Madam Speaker, I ask unanimous consent that all members may have 5 legislative days in which to revise and extend their remarks and insert extraneous material on H.R. 4639.
Without objection. Pursuant to House Resolution 1149 and Rule 18, the Chair declares the House in the Committee of the Whole House on the State of the Union for the consideration of H.R. 4639. The Chair appoints the gentleman from Alabama, Mr. Carl, to preside over the Committee of the Whole.
The House is in the Committee of the Whole House on the State of the Union for the consideration of H.R. 4639, which a clerk will report by title.
A bill to amend Section 2702 of Title 18 United States Code to prevent law enforcement and intelligence agencies from obtaining subscriber or customer records in exchange for anything of value, to address communications and records in the possession of intermediary internet service providers and for other purposes.
Pursuant to the rule, the bill is considered read for the first time. General debate will be confined to the bill and shall not exceed 1 hour, divided and controlled by the chair and ranking minority member of the Committee on the Judicial and our respective designees. The gentlewoman from Wyoming, Ms. Hageman, and the gentleman from New York, Mr. Nadler, will each control 30 minutes. The chair recognizes the gentlewoman from Wyoming, Ms. Hageman. Excuse me.
Mr. Chair, Mr. Chairman, I yield myself such time as I may consume.
The gentlewoman's recognized.
Today, the House will vote on H.R. 4639, the Fourth Amendment is Not for Sale Act. Last July, the House Judiciary Committee favorably reported the Fourth Amendment is Not for Sale Act by a vote of 30-0, with 1 member voting present. This bill makes crucial changes and closes a glaring loophole that allows the government to sidestep the requirements of the Fourth Amendment to purchase data of Americans. I thank my colleague, Congressman Davidson, for introducing this much-needed legislation. This bill is the result of years of bipartisan negotiation, and I look forward to this debate and vote. The Fourth Amendment guarantees that all of us the right to be free of unreasonable government searches and seizures. However, the law and doctrine concerning the Fourth Amendment has failed to keep pace with the development of digital technologies. Nearly 40 years ago, Congress passed the Electronic Communications Privacy Act, or ECPA, in an attempt to navigate the digital age. But it's clear that legislation is now insufficient to protect the constitutional rights of Americans. It is time that Congress accounts for the technological advances that have occurred in the decades since ECPA was passed. Today, seemingly every American carries a smartphone with them wherever they go. These devices contain vast amounts of information of Americans, such as where they travel, what they purchase, their health information, and so on. As the Supreme Court has noted, these devices, quote, hold for many Americans the privacies of life, end quote. Before the modern internet, the Fourth Amendment required law enforcement to execute a search warrant and subpoena the items they wish to review. The officer executing the search would have to provide a copy of the warrant and an inventory of the property seized. But today, federal agencies often sidestep the requirements of the Fourth Amendment and access and collect massive amounts of private information on Americans by exploiting a legal loophole in the ECPA and Fourth Amendment doctrine. While ECPA prohibits communications companies from providing customer information to the government in the absence of a subpoena, warrant, or other court order, no such prohibition exists for providing this information to third parties, such as data brokers. Instead of going to a judge to demonstrate probable cause and obtain a warrant, government agencies like the Federal Bureau of Investigation, the Internal Revenue Service, the Drug Enforcement Agency, and the Department of Homeland Security can simply turn to data brokers and purchase mass amounts of Americans' data. The government is collecting vast amounts of data by purchasing it from data brokers or other third parties. Media reports have detailed that some data brokers have even tracked people at places of worship and at protests. While the Judiciary Committee has in recent years advanced major reforms to overhaul ECPA, those bills have not yet passed into law. It is long past time that Congress acts to protect the privacy of Americans. There is strong bipartisan support in Congress to finally address and close the data broker loophole. This bill is exactly the type of legislation needed to rein in the federal government and protect the privacy rights of Americans. The government is rifling through your personal information. You should have the right to know about it, but the government can just purchase your highly sensitive information from data brokers and use it against you without your ever knowing. The Fourth Amendment is Not for Sale Act would close this legal loophole and ensure that the government may only use existing statutes compliant with the Fourth Amendment to lawfully surveil Americans. When the government compels data brokers to disclose Americans' personal data, it should be required to get a court order. With this common sense legislation, the government will no longer be able to make an end run around the Fourth Amendment to purchase the data of Americans. I urge my colleagues on both sides of the aisle to support this important legislation. With that, I reserve the balance of my time.